We are going to get started. First off, I just want to say welcome, everybody. Good afternoon. We really appreciate you being here today. My name is Jared Bryant. I'm the office leader here with Faegre Drinker in Denver. And I just want to say on behalf of our office and on behalf of the firm, we are incredibly excited and we're honored to host this program. Honestly, each year this is a highlight for us, and I guarantee you this year promises to be no different. And I also just want to say we're honored to continue our tradition of hosting this program in conjunction with the University of Colorado Law School. And we're honored that each of these panelists has made time to be here to share their thoughts on yet another super interesting Supreme Court term. So with that, I would like to turn it over to Lolita Buckner-Ennis, the Dean of the University of Colorado Law School, to give a welcome on behalf of the law school. Again, thanks everyone for making it today.
And I'm going to stand back here because I have notes. Thank you so much, Jared. Thank you so much to everyone who is here today. I am absolutely thrilled to have this opportunity to welcome you all, both those of you who are here in person and those of you who are remote. I know that it is the case that a lot of you have attended this event before, where we review a number of highly significant cases of the previous term of the United States Supreme Court. And I know it's probably been said before, I'm going to say it anyway. This last term has, shall I say, given us much food for thought. And we're going to have the opportunity to explore that today. And so I want to extend all of you our gratitude for gracing us with your presence, both here live and remote. We're going to talk about a lot of cases today that have captured national and in some cases international attention because of their impact. We will talk about cases that have a broad range of issues encompassing a wide range of doctrinal areas, each one crucially significant and very often highly publicized. From constitutional matters that shape our fundamental rights and civil liberties, to the ways in which power is allocated to various branches of government, these cases reflect the diversity and the complexity of the legal landscape that we navigate. The importance of these discussions cannot be overstated. The impact of the cases reaches far beyond the confines of the courtroom, resonating in the lives of even seemingly very ordinary people. U.S. lawyers and legal scholars have been ardently discussing these cases and their profound influence on the law, and those same lawyers and legal scholars have often provided advocacy regarding one perspective or another. I do want to state, though, that beyond those of us who are lawyers, these cases have been attentively followed by lay people. And that's one reason that our presence here today is so important. We, in effect, become ambassadors locally, statewide, nationally, and even internationally in terms of the kind of information that we are able to go forth and provide. And attending events like this helps us all to become thought leaders and thought partners when it comes to U.S. Supreme Court jurisprudence. And that is true, of course, regardless of what perspective you take on the law. These cases today will, I am sure, enrich our understanding. However, I can say, and I just want to mention, some of you know that I just finished my second year as dean, and I can tell you that even with very short experience with this event, this is not only informative, this is also deeply entertaining. And so I commend to you this wonderful, wonderful opportunity. You guys are rock stars. Are they not rock stars? That's what I mean. And these are the kinds of people that we have the opportunity to hear from in the great state of Colorado. By the way, happy belated Colorado Day. These are the kind of people, thank you. These are the kind of people that we have the opportunity to hear from fairly regularly. And so we are proud and we are honored to have him here today. I'm going to turn the mic over to my esteemed colleague, Associate Dean and Professor Doug Spencer.
Thank you, Dean Innes. Welcome, everybody, to the 12th Annual Colorado Law Supreme Court Review. Thanks to Jared for the introduction and for hosting us today, and thanks to Faegre Drinker for continuing their support of this really important tradition that's building here in Colorado law. I'm very excited. We are very excited to see so many of you here in person, friends of CU and DU Law School. Some of you, I think, were trained at other law schools. That's fine. You've chosen Colorado as your home, and we're very happy to have you here with us today. I've been told there are more than 300 people joining us virtually, so we have quite a crew that's here to be entertained, apparently, and to learn, I hope. I'd also like to thank our panelists who prepared a few thoughts about some of the most important cases and are going to help us understand where the court is at on some of these issues. We'll hear from Aaron Van Oort, who's a partner at Faegre Drinker in the Minneapolis office, Helen Norton, University Distinguished Professor, Roth Gerber Chair in Constitutional Law at CU Boulder, Eric Olson, Solicitor General Emeritus of the state of Colorado, and we're hopeful that we'll be able to hear from Shannon Stevenson, who's the current Solicitor General, although she will be joining us virtually, and we're working on some of the technological issues to get her connected so that we'll be able to hear her. Now, as the Dean just mentioned, as in other terms, the court has not shied away from important hot-button issues this term: affirmative action, student debt, water rights, voting, and religious rights. Many of these opinions are extremely salient from an ideological perspective, and it may ask some people to ask, who's winning? Much has been made of the 6-3 supermajority of Republican-appointed justices on the Supreme Court, but Republicans will be some of the first to tell you that the 6-justice block is not a monolith. And we saw that in this term. Just 5 cases were decided by an ideologically split 6-3 margin. That's down from 14 cases last term. The liberal justices certainly have found their voices. In some cases, literally, Justice Jackson has spoke more at oral argument than any other justice in her first term, more than any sitting justice than Chief Justice Roberts. Justice Jackson was also in the majority of cases more than Justices Thomas, Gorsuch, and Alito. And the 3 liberal justices were in the majority opinion more than 80% of the time, including a high-profile Voting Rights Act case. On the other hand, prominent liberals have been hesitant to see any silver lining in this term's opinions. Consider Linda Greenhouse's column in the New York Times a few weeks ago, where she asked readers to imagine falling asleep the night after John Roberts promised the United States Senate that he would merely call balls and strikes, and then waking up a few weeks ago to learn that race-based university admissions had been struck down, that environmental regulations were facing increasing scrutiny, the power of the administrative state has been curtailed, Roe v. Wade overturned, gun rights strengthened, and religious freedom elevated to new heights. So what is it? What is the story about this court? Has the court been captured by an ideological wing of a political party? Is the court threading the needle and finding important legal compromises in a neutral way that makes conservatives and liberals shift in their seats and a bit frustrated? Perhaps some types of cases are developing in one way and other types in a different direction. We hope today's event will provide some commentary and context for better understanding where the court is, and perhaps even where some of us think it might be going. In several instances, our panelists were heavily involved in the briefing and arguments before the justices, and so we're extremely lucky to hear their perspective and to learn from their experience. Now, I want to begin by saying a few words about this Voting Rights Act case that I referenced above. This is the case Allen versus Milligan. I made a typo already on the first slide, but in Allen v. Milligan, the court was faced with a challenge asking to strike down Section 2 of the Voting Rights Act. Now, Ronald Reagan called the Voting Rights Act the crown jewel of the civil rights movement. And here we can see one piece of evidence of the impact the Voting Rights Act has had on race and ethnic minority candidate elections. In Congress, this is African Americans elected in Congress. Here are Black and Latino candidates elected at all levels of government. I know those dates are really small, but you see a strong pivot right around 1965. The case at issue in Allen v. Milligan was a challenge to the congressional districts in Alabama. The congressional map that was drawn after the 2020 census is marked here in dark black lines. It's overlaid on a map of Black voting age population in the state of Alabama. According to the 2020 census, the Black population of Alabama was 28%. Alabama has 7 congressional seats. If there was proportional representation, Black voters would be able to elect candidates of their choice in 2 out of 7, but the way that Alabama drew its map, they had political power in 1 district, and you can see it. In the southwest of the state, a large percentage of Black voters in Alabama were packed into a single district. And then elsewhere throughout the state, you can see how the state legislature cracked the Black population between different districts. And in the trial court, the judges held that Alabama must draw a second Black opportunity district to be compliant with the Voting Rights Act. And that was the decision that was appealed to the United States Supreme Court. To understand what the claims were being made, I just want to walk quickly through the anatomy of a VRA case. So in order to win a Voting Rights Act case, it's kind of technical, and you have to show the court some preconditions. This is akin to a redressability analysis. You have to show the court that if they get involved, they can actually redress the harm that you're alleging, which is that the voting power of a racial minority group has been diluted. So the first step is to draw a map and to show that it's possible you could draw an additional majority-minority map. The term majority-minority means there's a majority population of the minority group. And that's what the plaintiffs were able to do. In order to draw a majority-minority district, you have to think about race. How else will you know if your district has a majority of Black or Hispanic population unless you're thinking about race? That turned out to be a big problem. With that evidence of a map, you must show there's evidence of racially polarized voting. And if you're able to show this evidence to a judge, then you're given permission to introduce all kinds of evidence that's been laid out by the United States Senate in a 1982 report, but a totality of circumstances. You show a history of discrimination, you show disparities in education and health outcomes, and a whole plethora of evidence can be shown in the court. At the end of that case, if a judge determines that a state is liable under the Voting Rights Act and needs to draw new maps, then it asks experts in the state to produce remedial maps, maps that will actually be used. And these maps need not be majority-minority district. If you're following this case in the news, you'll know that Alabama drew maps after the Supreme Court heard this case, and they drew maps that were not majority-minority, and this is going through another process. But it must be the case that there will be 2 districts in Alabama where Black voters have an opportunity to elect a candidate of their choice. What Alabama was really picking up on was the fact that in prior cases, the Supreme Court said you cannot draw remedial maps while thinking about race, because that would violate the 14th Amendment's promise of equal protection. And Alabama said, well, we want you to apply the same standard to that first step in a lawsuit. You can't think about race when you draw that first map, which would be impossible, which means if you just wildly started randomly or race neutrally drawing lines on a map and hoping that you could come up with a second majority-minority district, in practice, you never would be able to do so. And so Section 2 would essentially become useless. Nobody would ever be able to win that case. The Supreme Court did not accept this argument. In part, it's worth noting that the illustrative maps are drawn by plaintiffs who are not state actors and not subject to the 14th Amendment, so it seemed a little strange to argue that the requirements for a state actor drawing a map at the end apply to plaintiff, private parties, or public groups drawing those in the first place. The second ask that Alabama had was for the court to rely on computer simulations to establish a baseline. In the interest of time, I'm not going to get into this. I'll note that there was evidence submitted to the court that they relied on that showed that relying on computer simulations, the very same computer simulations that they were wary of in Rucho in 2019, would have decimated minority voting rights by shrinking the number of districts. In fact, if you look at the numbers, and this is what was presented to the court, there would be 5 Black members of Congress if we relied on computer sampling to tell us how many African-American candidates would be elected to Congress out of 435. And even Chief Justice Roberts, who's been no strong defender of Section 2 of the Voting Rights Act, said, I don't know what the Voting Rights Act means. It definitely does not mean that a Congress of 435 people have 5 African Americans in it. That can't be what its promise was. And so I think in this case, Alabama asked for too much, and they swung for the fences, and they missed. And I think that's part of the story, at least how I view this term. Some of the cases that came out in a surprising way, a lot of that had to do with the specific questions asked, with the facts alleged, and with the way the court was viewing its shift in a longer term trend. With that, I'm going to turn the time over to Aaron Van Oort. He's going to talk to us about affirmative action, among other things, and invite Aaron to come up to the podium for purposes of continuing with our camera. So thank you.
Awesome.
Yeah, thanks everybody. I get to talk about the affirmative action cases today, and it's interesting. I think there are 3 words all starting with D that you may experience as we're going through this. The first is dissonance. Having just gotten done talking about a case where the focus was entirely on race and actions were being taken based on race for the purpose of addressing issues relating to race, we're going to go to a case where the Supreme Court held you can't do that. Under the same equal protection clause that applies in this context and there. And so there may be some dissonance between that case and this case. The second thing is you may be feeling some discomfort because the reality is race is really hard to talk about. It's very personal. Humans haven't been very good at it. We're not all that good at it now. And for a long time, right, it's been hard to address any of these things directly. And that's still true. And I don't think that's going away. I think the only way through is to be willing actually to start having the conversations while we're feeling uncomfortable and build the relationships. But you did. The third is discussion. And what I've noticed is that there have been more conversations that I've heard directly talking about race and consequences and facts and different racial experiences and what to do. I've had more of those, and I've seen more of those in like the past 30 days than probably the prior 10 years, at least where I was. And one of the interesting things about the Harvard and the UNC cases is it seems to have been provoking that. So, dissonance and discomfort and discussion sort of are at the center of this. What I want to do is just in the short setup here. The opinion set here is 237 pages long. Most people don't have time to read that, so I'm just going to take a little bit and show you guys what each justice said to set the precursor for conversation later in our question section. So the question was phrased, should the Supreme Court overrule Grutter versus Bollinger and hold that institutions of higher education cannot use race as a factor in college admissions? The answer, as you guys have heard from the court, was 6-3, no, you can't use race. They didn't say they were overruling Grutter, but they were, and some of the concurrences say that. You just heard Doug talk about the 6-3, and there are 5 cases decided by the 6-3. Well, this is one of them, right? This is that lineup. 6 out of the 9 justices wrote, and just to orient yourself to what you're saying, the green is the majority, yellow are concurring, red are dissents. So the chief wrote the majority opinion. Is entirely expected, at least by me, because he takes high-profile things and writes it in a way to try to bring the temperature down. That's part of what he views his role. Justice Thomas wrote a concurrent opinion. Justice Gorsuch did. Justice Kavanaugh did. And then the principal dissent was written by Justice Sotomayor. And then another dissent was written by Justice Jackson, who participated only in the North Carolina case, but it made no practical difference there. One other thing you'll notice, and I'm going to start with the chief. The majority opinion is entirely devoted to the Equal Protection Clause of the 14th Amendment. You may be wondering, well, Harvard's not a state actor. Why am I reading only about the Equal Protection Clause? It's because the parties had agreed that Title VI of the Civil Rights Act, which does apply to universities that accept federal funding, meant the same thing as the Equal Protection Clause, which enabled the chief to write this really simple, streamlined opinion focusing just on the Constitution and not have to deal with it. Justice Gorsuch, when we get there, actually disagrees. He thinks Title VI is stricter than the Equal Protection Clause, which is going to create some litigation issues and already has. But so just to walk through what the chief did is starts with the Equal Protection Clause and what I would characterize as sort of a textualist formalist view. It says, the 14th Amendment says no state shall deny. Well, let me get my text so I get it exactly right on this. No state shall deny to any person within its jurisdiction the equal protection of the laws. He says, well, what that means is if you can't deny equal protection of the laws based on race, you can't do it no matter what race it is. And that's where we start. It's universal. And if you accord different races, different protections, that's not equal. He moves on that then to apply this specifically to universities and says in the context of strict scrutiny, at least 3 things apply to universities. Number 1, you can't use race as a stereotype or a negative. Number 2, they have to end. And number 3, whatever it is that's cited as the compelling interest has to be measurable. And he went through and spends time discussing and says, none of these things are met here, and therefore we're striking it down. And then here's where it gets to the conversation, because in the last part of his opinion is he addresses directly to the argument of the dissent. And what you'll see in these opinions is that some of the same conversations that are happening more broadly in society are happening in these opinions talking to each other. And what you'll see is 2 different viewpoints on this. One, the majority viewpoint says, well, hold on, let me pause before I get to the differences, because it's important, I think, to cover similarities. First, there's not a single justice on the Supreme Court who thinks that racial discrimination against Black people didn't occur and hasn't been a problem. Like, there's nobody, and in our society, nobody holds that view except for lunatics and fringe people and people aren't paying. So nobody does that. So number 2, everybody on this court agrees that you can redress past discrimination on the basis of race, specific discrimination, with race-oriented remedies. Everybody agrees with that. The points of disagreement are, well, how close does the remedy have to be tied to the discrimination? Like, is it the same people, is it the same event, or is it something broader? The majority says no, not broader. The dissent says no, broader. Right, and then the last thing, everybody on this court, in every opinion, agrees that ultimately we're trying to get to a place where we're not discriminating against each other on the basis of race in any way. Like, there's nobody on the court who says, really, the ideal universe, the ideal world is a world in some state where we're still discriminating on the basis of race. We're just doing it in the right way. Like, that's not anybody's endpoint. The disagreement is how to get from here to there, right? And the majority basically says the place to get from here to there is, as a legal matter, stop discriminating now and count on people to close the social gaps. The dissent says that's not going to work. There's no way, given the gaps that exist, that you can get from here to there just having this equality, right? So that's the conversation, right? It is a much more intelligent conversation than you see on like Twitter or the news, right? But those same basic goals, I think, are reflected largely what's going on. So here's the chief, and he's responding to the dissent, and he finds it very troubling that the dissent's proposal is that the judges applying the Constitution get to decide when discrimination is okay, when it is being applied in favor of the right people for the right reasons and the right amount, right? That's the concern of the majority. Okay. So then we switch to Justice Thomas, who, and I've just excerpted, I can't do any better than he did. He writes separately to offer an originalist defense, right? He's an originalist. He's not a pragmatist in any way, shape, or form, originalist. And to explain the flaws of the court's Grutter jurisprudence, by which he talks about practical consequences, what happens when you are discriminating in order to remedy past or current social issues. He talks about the problems of that from his point of view. And then to clarify that all forms of discrimination are done. And I'm not going to go into that, but if you want to read a good conversation, read his opinion and Justice Jackson's, and have the conversation going back and forth on what they focus on. Justice Gorsuch wrote a concurring opinion. The major portion, there are 2 things that he wanted to do. Number 1, he says, I think the statute, Title VI, is even stricter on the basis of race in the Constitution. So, while there may be some justifications, he thought, if you can meet strict scrutiny under the Constitution, he doesn't think there are any under Title VI. All right, so that's going to get litigated. And the second, you'll notice here, call out, Title VI is identical to Title VII. Those of you who are thinking your Title VII is employment, right? And so I was looking at this coming out and started talking to people and clients and said, just so you know, whatever happens in this case, there's going to be spillover into employment. He made it express, and so he's already being cited on that. So the employment litigation is coming. But that was the purpose of him. Justice Kavanaugh wrote a concurring opinion just to say, the short opinion is say, what we're deciding today is consistent with precedent because we said in all our university precedent that the ability to use race-conscious methods in admission is time-barred, and we've run out of time. That's the only purpose of writing that. So pass over that. Now we get to the dissents. And the primary dissent is Justice Sotomayor, and she starts from a different place. She doesn't start by saying the 14th Amendment prohibits you from denying equal protection on the basis of race. She has a broader affirmative statement saying that the Constitution enshrines a guarantee of racial equality, which has this proactive effect more than negative, this ability to go out and even some things out, right? And in contrast to the majority, which views Brown versus Board of Education as outlawing discrimination, she reads it as allowing race-conscious remedies. And then she goes on from there and basically, affirmative steps, as her argument, are permissible and necessary when neutrality can't get to equality. So notice what she's talking about. She's talking about closing actual statistical gaps that exist between racial groups and what's allowed there. Contrast that from the majority's more formalistic approach. And then, right, here's the guts of it, saying, the court concludes that indifference to race is the only constitutional permissible means to achieve racial equality. She says this rests on the illusion that this was a problem of the past, and it's not. And ignoring race will not make an unequal society equal, right? This is the dispute over, okay, what's the step from here to where we're all trying to go? And she's making the strong argument that you have to be race conscious. And then Justice Jackson starts out her opinion by saying, look, I'm not adding to Justice Sotomayor's legal discussion. I'm a justice of the United States, though, and I don't think a lot of people have read just how pervasively, and this is me paraphrasing her mind, so I may be getting it wrong. I don't think a lot of people have read or are aware of just how pervasively the government did discriminate against Black people and how recently it's happened and how it has happened on economic areas. And so I'm going to write about that so that as part of this conversation, a lot bigger part of the country knows what's going on, because once you read this, you feel differently about the legal arguments that you've just read. And so to go back to a point, if you want to read a discussion back and forth that gives, like I said, a highly intelligent, highly researched conversation between two people who have different views on this, Justice Thomas and Justice Jackson are it. So we're being sponsored by a university here. I imagine you guys have been thinking about this. And it's not getting easier for you. And then there's employment. And so since this opinion came out, I was talking with a friend of mine who is at a Fortune 5 company yesterday, who was telling me how they have gotten letters from both Republican attorney generals saying you can't, you've got to stop your aspects of your DEI programs. And she said, we have also gotten letters from Democratic attorney generals saying you have to continue. So they're in the middle of the fire. I don't know that colleges have gotten those letters. You've gotten them too, okay? So I'm just gonna come back, discomfort and discussion. It's not going to get more comfortable in the short term, and there's gonna be a lot of discussion. We'll continue it here later, but at least me personally, I'm relieved we can talk about it. I'm really relieved that we can do that, because there are a lot of smart people, and I think we can do better than we've done. on this. So with that, that's enough of the stage setting. I'm going to hand it off to Professor Norton next to go through some really interesting speech cases.
Good afternoon, and thanks so much for joining us. I'm going to start with Counterman versus Colorado, and I'll note in the interest of full disclosure that I was part of the team that included Eric and Shannon and a number of other colleagues who represented the state of Colorado. So I was not a disinterested observer of this case, also 303 Creative that Eric's going to talk about. Now, this is a First Amendment case. As you know, the default free speech clause rule is that when the government regulates speech on the basis of content, the courts treat that regulation with great suspicion. The government is usually in all sorts of trouble. But it turns out that over the years, the Supreme Court has recognized, identified a handful of categories of speech that it treats as entirely unprotected by the First Amendment. So the government is free to regulate that speech. And this handful of categories includes obscenity and child pornography and fighting words, incitement, a few others, and relevant to this conversation, true threats. But while the court has long held that true threats are unprotected by the First Amendment, it has never specifically defined when speech rises to the level of true threats. That brings us to Counterman versus Colorado. Billy Counterman is the petitioner in this case. He did not know and he never met a woman that we'll refer to as CW, who was an aspiring musician. Nevertheless, over a 2-year period, he sent her hundreds of Facebook messages. They started out relatively innocuous, but weird, suggesting that they had a relationship. And they escalated to more disturbing language of the sort that I put up on the screen. CW repeatedly blocked him. Again, she's never met him. She doesn't know him. She repeatedly blocked him without success. He created new accounts and started the barrage of messages anew. Ultimately, CW suffered harm to her mental health. She stopped performing publicly. She stopped walking alone. She withdrew from social engagements and finally alerted law enforcement. And Mr. Counterman was eventually convicted under Colorado's stalking statute. He appealed his conviction, arguing that his speech did not rise to the level of true threats, was not threatening, and thus was protected by the First Amendment, and his conviction should be overturned. So this case required the court to figure out, how do we define true threats? More specifically, do we define them from the speaker's perspective or the listener's perspective? Mr. Counterman, the petitioner, argued we should take the speaker's approach. He argued that the First Amendment requires the prosecutor, or if we're in a civil case, the plaintiff, to prove that the speaker specifically intended that his speech make his target fear for her physical safety. Colorado's position, which was at the time the position of the majority of jurisdictions, said we should look at it from the listener's perspective, that the First Amendment requires only that the prosecution or the plaintiff show that a reasonable person in the target's position, considering all of the circumstances, would understand the speech to be threatening their physical safety. A majority of the court instead chose a middle path. It chose a recklessness standard, which requires the prosecution or the plaintiff to prove that the speaker was reckless. In other words, the speaker was aware that there was a risk that the speech could be reasonably understood as threatening and chose to proceed nevertheless, disregarded that risk. Now, on the one hand, this standard is considerably tougher on stalking victims and other victims of threats than the status quo in Colorado and most other jurisdictions. As Justice Barrett's dissent pointed out, any subjective threat standard that requires the prosecution or the plaintiff to prove what's in the speaker's head will protect a number of threatening speakers. It will protect the delusional speaker who's unaware that their speech is instilling fear in the reasonable listener. It protects the devious speaker who takes care to strategically and effectively disclaim any awareness of the effect on the listener, and it, in her terms, it protects the lucky speaker who leaves behind no evidence of their mental state. Now, on the other hand, the majority declined the petitioner's standard, which would have been considerably tougher on victims of stalking and other threats that would have required proof that the speaker specifically intended or knew that the speech would cause their victim to fear for their physical safety. Now, my own view of this case is that it's important to recognize that there are free speech interests on both sides. There are substantial First Amendment interests on both sides. On the one hand, for sure, we should worry about a standard that over-deters valuable speech, that is too quick to punish speech, such that folks are worried that they'll be punished for what they believe to be political hyperbole or jokes, that sort of thing. And, not but, on the other hand, there's plenty of evidence that shows how threats disrupt their target's life in ways that silence speech. And we saw it in this case. CW stopped performing, stopped making art, stopped participating in public life. So in other words, threats themselves silence valuable speech. And I think any commitment to robust free speech principles recognizes that there are speech interests on both sides of these sorts of cases. The other thing that I want to talk about very briefly is a couple of cases involving social media platforms this past term. And frankly, they may be more notable for what they didn't decide than for what they did decide. Now, social media platforms face quite a bit of litigation from plaintiffs who allege that the platform's practices are causing serious harms. And as an example, I'll talk about briefly litigation that's currently ongoing in the Northern District of California. It's multi-district litigation where the plaintiffs, who are the surviving family members of children who have been hurt in various ways and sometimes committed suicide, who are asserting that the platform's use of algorithms and dark patterns to manipulate kids, children, into staying online for long stretches of time, that those platform practices are harming kids' physical and mental and emotional health, and that the platform should be held liable either under tort law for defective product design or maybe under consumer protection law for unfair trade practices. Now, there are several key issues that come up in this sort of litigation, and we're going to see quite a bit of this litigation going forward. First is, do the platforms have immunity from liability over a legal provision called Section 230 of the Communications Decency Act? And the idea underlying Section 230, when Congress passed it several decades ago, was that if platforms are not going to provide the service of enabling users to post their speech, if they're going to be held liable for the illegal harms that their users' speech inflicts. So Section 230 generally immunizes a platform from liability when one of their users uses that platform to do something illegal, like threatening somebody or defaming somebody or defrauding somebody. But Section 230 doesn't immunize platforms for their own content and for their own practices. So this first question that is hotly litigated in most of these cases is, are the platforms immune under Section 230, which is another way of saying, is what concerns the plaintiff, is it really what the users are posting? Is that what troubles them? The user speech? And if that's the case, the platforms are probably immune under Section 230. Or is what's concerning the plaintiff, is it actually something that the platforms themselves are saying or doing, in which case the platforms are not immune under Section 230. The second contested question in these sorts of litigation is, okay, let's say Section 230 immunity does not apply. We can go forward with a case. Can the plaintiffs establish their cause of action, whether it's a tort claim or a consumer protection claim, or as I'm about to discuss, an aiding or abetting claim? And then finally, even if the plaintiffs can show the elements of their cause of action, the platforms argue that in most cases, holding them liable is actually punishing them for their speech, viewing their practices, their algorithms, their interfaces as protected speech, so that the argument that the platforms make, that is being litigated right now in a number of areas, is you can't hold us liable for this because that would be punishing our speech in violation of the First Amendment. So lots going on there. So getting to the cases that the court did consider this past term, Twitter versus Tanmay and Google versus Gonzalez, These were lawsuits brought by the families of victims who were killed in ISIS terrorist attacks in Paris and in Istanbul. And the families brought suit under a federal law that enables those injured by terrorism to seek money damages from those who are responsible for the terrorist attacks. And the plaintiffs here alleged that various platforms aided and abetted ISIS and thus shared responsibility for the attacks by knowingly allowing ISIS and its supporters to use their platforms and the platform's recommendation algorithms to push content, to push ISIS content to users, and that content served as tools for recruiting and fundraising and spreading ISIS-related propaganda. And the plaintiffs also alleged that the platforms profited from ads placed on ISIS's posts and videos. Now, both of these cases came from the Ninth Circuit, which had held that many of the plaintiffs' claims were barred by Section 230 immunity. In the Ninth Circuit's views, most of the plaintiffs' claims were really concerns about ISIS's content and not about the platform's own practices. And if it's all about the user's content, then Section 230 immunity applies. So many folks expected that the court took these cases to tell us more about how it thinks about Section 230. Does it interpret it broadly or narrowly? Is it quick to find Section 230 immunity, end of case? Or is it slower to find it? The case can continue. But a unanimous court avoided that question and instead held it didn't matter, because in this particular case, the court found the plaintiffs couldn't establish their aiding and abetting cause of action, even if Section 230 didn't apply. So a unanimous court held that this aiding and abetting claim requires the plaintiff to show that the platforms engaged in affirmative wrongdoing. In other words, that the platforms knowingly chose to provide substantial assistance to ISIS. And the court said, that's not what we see here. The court said, what we see here is at most the platforms were passive participants. And they just provided infrastructure. And the analogy, as you can see, that the court used was this reminds us of phone companies or internet service providers who are not responsible when criminals use the phone or the internet to commit illegal activity. Justice Jackson joined that unanimous opinion, but concurred to emphasize we shouldn't read too much into this. She said this is a very fact-specific case. This may not be terribly relevant for the cases that are yet to come, where plaintiffs are alleging that platforms have caused illegal harm. So we haven't decided much today. And certainly many cases have yet to come. So as I mentioned, I think these cases are more notable, these last two cases are more notable for what they didn't decide than what they did decide. They leave us with lots of unanswered questions about how broadly or narrowly we should understand Section 230 immunity. And they left us with lots of questions about, even if 230 immunity doesn't apply, whether and when plaintiffs can show that platforms are causing illegal harm. Eric.
Thank you. It's great to be back doing this again. I had the great privilege of working for Phil Weiser at the AG's office for nearly 5 years and left the office about a month ago, which means I don't get to work on the cases like this that we got to work on over the time. It also means I can speak my mind a little bit more now that I'm not working at the AG's office. So I want to talk about 3 cases today, 2 of which our office was involved in. And then, as some of you have been here before know, I like to sort of bring some advocacy lessons for all of us from what happened at the court, so that those of us like me who won't do this anymore, who aren't in front of the Supreme Court, can still learn some of the good and bad of what advocates did there. But the first case I want to talk about is 303 Creative versus Alanis. This is a follow-on to Masterpiece. This is a case about, at bottom, the relationship between First Amendment in the District Court and 10th Circuit. It was both free speech and free exercise claims, and public accommodation laws, civil rights laws that say if you open your business to the public, you need to serve everyone. We won at the District Court, won at the 10th Circuit in a difficult to defend decision, but nonetheless a victory. And then the Supreme Court took the case, and it was, how do we say this? It was a lot of work, but we got the outcome I think we all thought we were going to get from the beginning, which was the 6-3 is another one of the 6-3 decisions. The court held that this website designer who claimed she wanted to enter the business of wedding websites design could not or did not need to serve same-sex customers who wanted to buy same-sex wedding websites. And what I want to talk about is how differently the 6 and the 3 frame the case, and lessons for all of us and how we can think about the cases that we have. But it was as if you read the opinions and they were on 2 totally different fact patterns, 2 totally different protagonists, and 2 very different approaches to what those framing decisions meant for how the case came out. Justice Gorsuch centered his analysis on this poor woman who just wanted to run her business without being interfered with by the state. That she, does this work, she wants to expand her offerings, she laid the groundwork, she hasn't done it because she's worried that if she does so, she'll be forced to express views by the state that she disagrees with. We obviously didn't agree with this frame and really fought hard to change the frame unsuccessfully at the court. But this is how Justice Gorsuch looked at the case. And when you read these 2 paragraphs, it's difficult to see the case coming out any way other than Colorado can't punish this poor person for expressing her views. Justice Sotomayor, in dissent, had a very different frame, which was the frame that we brought, which is this is not a speech case, this is a conduct case. And if you participate in public life, commercial public life in America, you can't engage in conduct of turning people away just because of who they are. And Justice Sotomayor basically adopted our argument and talked through, her protagonist was sort of the protection, sort of the American ideal in the way she looked at the case, and that we as Americans have the ability to ensure that all of us are treated equally in public life, in public commercial life, and that because you are deciding who can access your business because of some characteristic they have, that's not consistent with America under her view. And, I was thinking about this frame, and Helen, who was a sort of key leader on the team throughout this, identified early on that because it's a pre-enforcement challenge, there are no victims of discrimination in this case. And so this case, and you saw it in the way in which the media that Alliance Defending Freedom, who represented 303 Creative, the way that they presented the case was this sort of, fearless, courageous citizen standing up for her rights that really took the victim of discrimination, took the experience of the person who was told, because of who you are, what you look like, who you love, you don't belong, and just excised that from the story. And I joked, it's sort of like the superhero this was the story that ADF took to the court, right? A person standing up for their values in a way that totally cut out the experience of others that had to do with the case, and even was very different than Masterpiece Cake Shop, where, if you recall from Masterpiece Cake Shop, there was an actual customer, a gay couple, Charlie Craig and David Mullins, who went to the bakery and said, "I'd like this cake." And this is them outside the Supreme Court after Masterpiece Cake Shop. And there's a link at the bottom to an editorial they wrote in USA Today right after 303 Creative came out, that in a way much more powerful than I can, talks about how the court's decision removes the experience of those who face this discrimination, who aren't able to access public commercial life, just as they weren't. And it's a very powerful statement. And then when you think about how our progress as a country in terms of living up to our ideals of ensuring who is able to participate in our commercial public life has played out almost always where there's been progress, where there's been advances in equality in America. You have situations where there are actual people. This is a sit-in at a lunch counter in the South in the 60s. There are actual people who are showing the impact that this conduct has on them and making that impact not theoretical, but real. And using that story, be it, Rosa Parks on the back of the bus, be it the brave students who integrated a lot of the school systems throughout our country in the 60s and 70s. Those sort of were the protagonists of the story in a very effective way. And I think when you're dealing with these issues, but almost in any case, it's really important to be deliberate about who's the protagonist in your story. And whose story are you telling? Are you telling the story of someone who is sympathetic? Are you highlighting the features of the dispute in a way that helps you present your case the most effective way possible? Here, ADF did an exceptional job of sanding out the rough part of their case and highlighting a very sympathetic part of their case for this audience. And, because they were sort of filed first, it was difficult for the state to change the frame of that story. And their story got 6 votes, our story got 3 votes, unfortunately. So now I want to turn to 2 other cases that have very different outcomes at the court, both involving Native American tribes, one of which Colorado was involved in, but the outcomes couldn't be more different between the 2, and trying to think about why that was and how the court addressed seemingly similar issues but reached very different outcomes. So the first is Halland v. Burkine, which is a challenge to the Indian Child Welfare Act, but it really is part of a larger effort by a number of interest groups, including a lot of corporations, to undo the special status that Native American tribes have over certain business and natural resources in our country. And this was sort of the tip of the spear to try to make that change, but it was a challenge to the Indian Child Welfare Act, which basically was passed in the 60s to stop the pernicious practice at the time of removing tribal children from their homes and communities, and basically destroying tribal communities by taking their children away. And it does that in a number of ways, but the 2 most salient features are that it requires states in family law courts to give preferences to placing tribal children with children of that same tribe or another tribe before they go sort of through the traditional system, and that it requires state to carry this stuff out, requires the state courts to do it themselves. It's not the federal courts doing it. It's a law that says state courts have to do this. So a whole bunch of challenges. I think Justice Barrett, in her opinion for 7 of the court, says super complicated, but basically every challenge loses. They, on the merits, affirmed that Congress has plenary authority under the Indian Commerce Clause to regulate our country's relationship with the Indian tribes, that requiring this sort of preference isn't a commandeering of the state court challenge of state courts or states to do the work. And they didn't reach on the merits that the claim of it, that this violates equal protection. Tribal status under the Constitution is political, not racial, and so they didn't reach the merits of whether this was a violation of the Equal Protection Clause, because they found that the people who were sued here, which was the federal government, couldn't redress the injury that the plaintiffs alleged they faced, because that injury was faced by the state decision makers, the state family court judges, et cetera, and that it didn't violate the non-delegation doctrine by giving some legislative authority to the tribes to shape some of these preferences in some circumstances. And so a resounding victory for the tribes, Justice Gorsuch in his concurrence writes a very strong, very empathetic story of the history of the relationship between the U.S. and the tribes. As he's established himself, this is an issue he cares very deeply about, and is unlike the lack of empathy shown in 303 Creative for what the victims faced, is incredibly empathetic to the plight of Native Americans in our country, and writes a very powerful concurrence. But the real standout for this, I think a lot of people thought that ICWA would not withstand scrutiny. It had been a carefully curated case. Ian Gershengorn represented the tribe at oral argument and gave one of the best oral arguments I've heard in my lifetime. He saved the case at argument in many ways. And it wasn't just him, he was part of a larger project. The tribes, as this podcast called This Land by Rebecca Nagel talks about, the tribes kept losing in the courts, and in the early 2000s started a tribal Supreme Court project to help educate Supreme Court bar advocates who were really good about tribal issues, to really give them a deep understanding of it. And it's paid off in several cases, including this one. But Ian did three things at argument that I thought were really effective. I just want to highlight for what we do, for tips for all of us, is that he recognizes there's some hard cases, and he doesn't overstate his position, and speaks, as I try to tell folks in our old office, he's helping the court answer these hard questions. And so he's just getting hammered by Justice Alito on these really hard hypotheticals. And he's like, look, this is how I think about it. I'm doing my best here so we can work through this together without sort of feeling like he has to fight back or really, pound the table to have an effective response. But he builds a lot of credibility. He's funny, right? Justice Gorsuch asked him a question about something, and he has sort of a cute turn of phrase. Now, being funny is risky as an advocate. Not all of us can get away with saying that way madness lies, but it's also really effective and very memorable. And so as we talk about the AG's office, like, the way to be a good lawyer is to be a really good version of yourself, right? And this is sort of Ian's personality, and he was himself this way. And then he's candid about his weaknesses. And this is in a conversation with Justice Barrett. He says, I think I'm right, but of all the answers given today, that's the one I'm least confident of. But really sort of expressing that, hey, if you have a case at the U.S. Supreme Court, there's probably some hard questions there, and you're probably not going to get 9 people to agree with you right away, and build the credibility by doing this. And candidly, for me, the flip side was that oral argument on 303 Creative, there was only one justice of the 9 who asked questions where they were exploring the hard questions. The rest of it was sound bites on both sides about, this or that. And I think having this ability to have a conversation is really effective. And so, I think I would recommend you listen to Ian's argument. It is exceptional, but he understands what happens in the real world. He uses humor, and he's candid with his weaker points. Which brings us to our last case, which is Arizona v. Navajo Nation, another tribal case. This is a case where Colorado intervened, but it was a dispute between the Navajo Nation sued the federal government and said, you, federal government, have a trust obligation to make sure that we have water for our reservation, because part of the deal was we moved here and you promised we could engage in agriculture, and you can't do that without water. So this is a Navajo Nation. As you can see, sort of the Four Corners area, Colorado, New Mexico, Arizona, and Utah. And you see that it's bounded by river, including where the red line is, that's the Colorado River. And so the Navajo Nation sued the federal government and said, basically, excuse me, this water is right by our reservation and we get none of it. We need some of it. And they had a very compelling facts. 30% of the households on the Navajo Nation do not have running water. They live on about 10% of the water per capita that the rest of Arizona does. There's some real challenging situations. I mean, this is a picture from some of the press coverage. Something like 50% of the households have to drive to get water for daily household use on the Navajo Nation. I mean, it is a very different world than almost everyone in this room experiences. And so what happened? They said, hey, federal government, you need to give us some water because you said that we could have this land to farm on and you can't farm here without water. The federal government said, what we give you, basically sort of the short flippant response was you get what you get and you don't throw a fit. Like, we get to decide what you want and you can't go to court and tell us that we're not giving you enough. We alone are the decision maker in terms of what you can get water-wise, what have you. Colorado and some other states intervened, and we said, basically, the Colorado River is fully allocated. There's like no surplus already. And so if you give water to the Navajo, then it has to come from somewhere. And all of us said we don't want it to come from us. We ended up filing a separate brief from the other states that basically was agnostic on the merits, but said, we want this, is the right way to have this decided is not some federal district judge in Arizona deciding this case. The right way to decide it is through what's called the law of the river, where the Supreme Court basically brings in all the affected decision makers. The court wanted nothing to do with our argument, relegated to a footnote and said, you wrong, didn't engage. But what they did do was pretty shocking. They basically, in a 5-4 decision, said, you get nothing to the tribes, and that the federal government can decide what you get, and it's tough for you that you don't have any water, but you have no enforceable promise from the treaty setting up the reservation, and you lose. And this opinion was issued a week after the Brackeen case. And so why did the switch? Right, there was one side where there was a very powerful tribal, the tribal interests were exalted, and in this case, they could not have lost in a more sweeping fashion. And so, a couple flippant answers and then a real answer, I think, which is, I think this reflects that the court doesn't have experience with what it's like in all of America. I know from some friends in the tribal community that Justice Kavanaugh, for the first time in his life, visited a reservation this year, right? Had never even been there. And I joke, this is his, fancy country club that he's a member of in Maryland. And, when you're in a place and space like this, what's happening in rural Arizona on a reservation is an abstract idea. It's not real. But then, so the flippant answer is that they don't care about the tribes. But then reading the argument and thinking about what happened, sort of 2 books and 2 arguments sort of really stood out to me. And this is, a Justice Kavanaugh question that I think sums up his approach. He's asking about an amicus brief filed by a bunch of water users in Arizona that unsurprisingly say, like, if we can't get water because it's going to the tribes, like, everything we know is going to end in Arizona. And he does it in a classic Kavanaugh way, which basically says, some people say the world will end if you win. I'm not saying I agree with that, but please let me know what your answer is. And it brought together a theme from 2 books, very, very different books, but I think are helpful for thinking about these kind of issues and why these cases came out differently. The first is A Sum of Us, which if you haven't read, I recommend reading. It's an extraordinary book by Heather McGhee that's basically premised on the question of how can it be that the same Supreme Court that desegregated schools in Brown very quickly after that said, yes, you have to desegregate your pools, but you can also disclose your pools entirely. And you can take something away from the whole community so you don't have to share it, and talks about a real zero-sum frame of how a lot of the high valence positions that the court or that the court and the politics have taken has really diminished what we can achieve together as a country. So highly recommend that. And this is a very zero-sum opinion, very much. And if the tribe gets anything that comes from somewhere else, Dahlia Lithwick and Heather McGee did a really interesting discussion about the zero-summiness of this court and talked about this case. And then the second, anyone who's been a defense lawyer, plaintiff's lawyer in the courtroom has heard about the reptile theory of litigation, where you challenge the way in which, if you're a plaintiff, that you get big verdicts, is you make the case about a threat to the community's safety, and that it's important for the jurors to step forward and protect their communities by ruling for your client, awarding a big damage against a corporation, et cetera. And I think this case that we see, the Arizona v. Navajo Nation case, is a good example. There's this myth of scarcity that the Arizona that Justice Kavanaugh highlighted in his argument is placed at risk because of the zero-sum approach, and that there's sort of an inability to think about how there can be a better solution where everyone does better. It's kind of crazy to have a state where you have such a huge portion of the state living in such poverty, and to say, no, we need to keep it this way, when if everyone did better, everyone would do better. And the case was really framed in a zero-sum way. And the themes that resonated with the court were the safety and security of the community. Now, the tribes painted a very powerful picture of the lack of safety, of the insecurity they faced because of their lack of water. But that didn't resonate with the justices. What resonated with the justices was the question we talked about, like, hey, the Arizona that we know will be changed by a different ruling. And so I think that helps explain why these cases came out differently. I know we're running late and Shannon's going to talk next, but anyway, these are just some observations on how to frame arguments, and how framing the arguments matters both in the Supreme Court and elsewhere. Is Shannon going to be able to participate? We don't know Shannon?
We had technical difficulties and weren't able to connect your audio.
Okay,
We'll
great.
send out a recording.
Okay, great. So we can do Q&A then?
Yeah.
Great.
All right, thanks, Eric, and thanks to everybody. As if you didn't hear Shannon Stevenson, we're able to see her but not hear her, and we really want to hear her. So we're going to have to invite her back for another event, certainly next year, another time. But that does leave us with about 15, maybe 18 minutes for question and answer. Yesenia will, if you'll raise your hand, bring the microphone to you so we can all hear you, and people participating virtually can hear us as well.
This is for Solicitor General Olson. In the 303 case, and I apologize if I misstate anything, but there were some stipulations agreed to by the state that made it, from my perspective, much more difficult for the state to win. Why was that done? Was it intentionally to heighten the contradictions and focus those issues, or something else?
So a great question. I would say three things in response. First, they were done in early 2017, before Masterpiece had even been fully briefed and decided. And so they were done in a very different context than we faced after Masterpiece came out. Second, we all, and it's also done by a different attorney general, different solicitor general, different, and I don't know sort of why they did that, but we're a busy office, and there's a lot of things that we try to do our work efficiently. And so you can see why it's done. I think a lesson learned, the second thing I'd say, is that a lesson learned for an advocacy tip is sort of Mirandize yourself on this, which is like, what am I saying that can and will be used against me down the road? And I think, particularly because Masterpiece hadn't been decided, there was not as much, there wasn't the blueprint to think about, hey, what could this mean down the road on the stipulations. And the third thing I will say to defend the stipulations is, ADF and Justice Gorsuch grossly misstate what they said, right? And if you read the stipulations in context and in full, they are not nearly as case dispositive as Justice Gorsuch made them seem to be in the opinion. So I have many beefs with the way in which Justice Gorsuch and the other five decided the opinion. One of the headline beefs is that it was a dishonest reading of the record.
Right here.
Hi, this is for both Solicitor General Olson and also Aaron. So you sort of focused on how important it is to have a protagonist and sort of what that can do for you. I guess my question is, there wasn't really a protagonist in Students for Fair Admission versus Harvard and UNC. So what do you think was sort of the deciding factor? What do you think got them across that hump? Because that was such a big thing that they didn't really have any protagonists in their case.
So I would say I would fight the premise of your question a little bit, in part because the former I was at before coming to AG's office litigated the trial case challenging Students for Fair Admission. And there the protagonist very much was, there are a wide swath of Asian applicants who who are the victim. And much of the most provocative evidence was how there were these victims that did not get a fair shake at Harvard. And so that sort of got lost in the Supreme Court. But that was the protagonist. And then the UNC case, I view it was like before judgment they granted cert, and they would not have granted cert had Justice Jackson not had to recuse herself from Harvard. It was just a pure vehicle so that she could sit.
I had exactly the same thought. Yeah, I thought they did an excellent job picking their protagonist because it was Asian students. And you get a very different emotional reaction and a very different history than if you had a group of white students. So I actually thought that part of the framing of that case was an application of what Eric talks about.
Might I jump in? I was close by the
Please do.
microphone. I confess that this is a very oversimplified question, so I apologize. But with respect to the Harvard UNC case, how does the entire panel look to the perhaps incipient legislation on reparations in California?
Oh, boy. Well, I haven't thought about it, but I'm going to think right now on the fly. You're going to see it. So, they said that one of the differences between the majority and the dissents were how closely you can have remedies based on discrimination, how close the link has to be in order to be constitutionally permissible. And this is another place where this is a disagreement between Justice Thomas primarily and then Justice Sotomayor, where they discussed laws passed in the 1860s after the Civil War, some of which were quite race conscious on that. And what Justice Thomas says is, well, they're direct responses to recent discrimination by the government permissible. So I think the way the courts would frame a question about state action, benefits based on race would be, is there a close enough link to discrimination the state actually enacted? You can imagine different ways of looking at that, close enough in time, close enough in people, close enough in all of this. But at least my first take is that's the way the analysis would be applied by this current majority of the court.
My question relates to record control. The Supreme Court seems increasingly willing, and we saw a couple examples today, to pick up on statements in amicus briefs or their own readings or their own literature reviews to look at very important things that help influence their views of cases. And I'm interested in what you think litigants can do to help constrain the court to the record before it, so that Justice Kavanaugh is not citing statistics from an amicus brief in the zero-sum analysis that Solicitor General Emeritus Olson mentioned. Or the other example that stood out was the back and forth between Justices Jackson and Thomas in the affirmative action cases, where there are very real, very important considerations being discussed, but those weren't citations to the record that they were citing there. So just interested in everyone's reactions on that development and litigation tips.
I'll go first and say something. A group of judges once had me give a presentation to them on the ethics of the record, which is a really fun presentation on that. And it turned out, as I was thinking about it, to be harder than I thought. And one distinction you can draw, I think, is between what classically were called adjudicative facts and legislative facts, where adjudicative facts, the facts about the particular case and the parties on that, obviously there are record constraints on that. And usually that's not the type of facts the justices go outside. The other is legislative facts, which is facts you know about the world and facts that inform the broader question and all that. In some ways, I think it's difficult to take the position that you want judges not to be able to rely on the best information on legislative facts. Because what if a really important question is in front of them and the parties do a lousy job, right? You would hate for a precedent that would be binding or a decision that would be binding on everyone suffer from that. Counter argument on that is that we have an adversarial system. We generally trust in that. And anytime you have a judge step out of the role of like a neutral adjudicator and take on some more proactive role, which happens in, Reptile is designed to get people to take a more active role, and it works. And I defend a lot of class actions, and I commonly see judges step out of a neutral role in a class action and take on a protective role in that. But I mean, those are different concerns on both sides. My bottom line conclusion as an advocate is win the amicus war. So given that it's happening and it will happen and it does make effects. And I'm particularly proud of an amicus brief I wrote in the California Prop 10 case on pigs and the Dormant Commerce Clause. Because I grew up on a hog farm and then got to clerk on the Supreme Court. So I got to write a brief for the American Association of Swine Veterinarians on a Dormant Commerce Clause case, and Kavanaugh cited it. We lost, but there you go.
I'll just say two quick things, which is one, and I'm sure Aaron remembers this too. When I clerked the court in 2002, they had this Curious George stuffed animal on a stick in the library. And I was like, what is that? And it was, there was an on-duty librarian who would answer any question you had about anything related to any case at any time.
It was amazing.
I mean, and then it was an email. It was a big innovation my year. They switched to an email. So you just email Curious George at whatever. And you could say something like, in 3C Creative, like, what other websites has Laurie Smith designed? And then within a day, you would get this like incredibly sophisticated information. And at first I was like, this is amazing. And then I was like, wait a minute, like the parties don't know we're doing this. There's no opportunity for anything. So my bottom line is that there is no restraint built in, particularly to the Supreme Court, and it's erratic on the courts of appeals. And so you can't fight it. You have to just win it. And we at the state are particularly ill-suited to do that because we don't have the resources to call up and say, hey, please write an amicus brief on this or that. But you can't ignore it. You ignore it at your peril.
So I have a follow-up just on Curious George, because Curious George was amazing. It was just the best. So I got done clerking for Scalia. I went back to Minnesota. I'm an associate in a big law firm. I've got to do my own research. And I was just feeling so bad, and my wife gave me a little Curious George just to put in my office and remember. So if you go to my office in Minnesota, there's still a little Curious George. So that's where he was. I was a little homesick for Curious George those first few months.
Aaron, I wanted to go back to what you were talking about in terms of racial remedies and like them needing to be tied closely enough to whatever past discrimination happened. And I was curious what your thoughts were on whether the opinion leaves any space for using explicit consideration of race to remedy like current bias, like implicit bias, and whether if it's tied more to what's currently happening as opposed to past bias, it's permissible.
I certainly, well, I don't know enough about Title VII to be really good on this. But my sense is that, you can bring disparate impact claims, which are based on showing statistical differences that happen regardless of intent. And you could act intentionally to eliminate those intentional differences, right? That's the law right now. So I think you could overcome that. I think the path to doing that would require some showing that you actually are not treating people equally according to some objective standards, right? And of course, that's not what's going on at the universities. That's not the problem right now. So I don't think it'd be very effective, you know, in terms of the universities using that rationale. To that, it may be in some other employment contracts or otherwise.
I have a question for Professor Spencer and Professor Norton. So last year at this event, I asked how the previous Supreme Court term would sort of change preparation for Supreme Court litigation going forward. So I'm curious as a follow-up, I mean, we got some insight into that, but how that sort of came up, how that preparation changed or how your strategies changed going in. And also whether you view the current, like the evolving jurisprudence or emerging jurisprudence, I don't really know what to call it. They called it dissonance. I think as a law student, I experienced it as whiplash. But is that more of like a burden shifting now? Are advocates in better positions putting their energy into things like legislative advocacy for rights that are at risk, like privacy rights at the state level? Or is creative litigation at the Supreme Court level still sort of a viable route to use for protecting these kinds of rights?
All of the above, right? Yes, and that's not actually a new challenge, right? Folks who are interested in civil rights work and anti-discrimination work in related measures have, over the arc of history, had to make these strategic choices. And there are various pivots in the arc of history where maybe they invest more in Congress some years and more in states and local legislatures other years, and more in federal courts in other years, and more in state courts in other years. So all of them have to be on the table. And I appreciate the question that we, especially those of us who train lawyers, right? We're training lawyers sometimes accidentally to see every problem as a litigation problem, when litigation is one of many tools. Hopefully that we're training you not only to have the hammer that is legislation, but also the pliers that is federal legislation, and the screwdrivers that are state courts. So all of them have to be in the mix. So the good news and the bad news is you don't have to choose.
We have time for one more if somebody's just chomping at the bit. But was, yeah, there we go. I know you're front row.
Okay, we can make this a lightning round. I understand the Supreme Court has granted cert on Chevron deference, so I'd love to know what your crystal balls say about where that's going.
I'll say lightning round, which is like, why bother? Because the court, I think this year has shown in particular that it's very sensitive to political pressure, and it does these things like 3C Creative is a massive change in the governing law of public accommodations law in America, even though the decision says it's not changing anything. And so Chevron is overruled, just like Lemon is already overruled. No one cites it, no one uses it. It's like the Lemon test was overruled before Gorsuch was like, oh yeah, we stopped doing that a long time ago. And so I think I was surprised they took it, because I don't know that there's much of a debate.
I'm going to cede my time to Professor Spencer.
I did not hear the question.
So what do you think is going to happen to Chevron?
From a broad perspective, I think what's interesting for me watching the court is that, you know, this idea of deference is also in a way a sense of humility, and I don't know that I get that so much from this court. I think they want to have a say on everything. So even in places where they're admitting, well, we'll allow these other branches, we'll allow some deference to administrative agency, but in, you know, all these other ways that we've now cabined out major questions and other things, you can only do the kind of work that we understand and that we would let you do. It feels very controlling to the extent that it even really exists as a doctrine anymore. I think, as Eric pointed out, I don't know that it really has much teeth, but it will. I do think that they'll still use it sometimes strategically to suggest some humility when I think ultimately that's lacking.
Yeah, I think they're going to do to it something similar to what they did to our deference, which is, you know, the courts deferring to agencies' interpretations of their own regs. And so they wrote an opinion that didn't overrule it, but to my mind, writes the rules in a way that you never have to defer unless they actually want to. I would My leading guess is they'll do something with Chevron like that, where it's not formally overruled, but you never have to follow it unless you want to. I'm going to say one more thing. I don't think 303 creative drastically changed the law, because to the point, I think the court read the stipulations, fact stipulations so narrowly that the thing that you always fight about, which is this speech or conduct, and is this accommodation or not? The majority was just to say, well, the stipulations took care of that. So I think all the fights are left in all the other cases. That's my take on that. So I would be surprised if that opinion has outsized influence, but we'll see.
All right, so we were so reverent after each speaker, and I think that was not acceptable. So we should clap and cheer for our panelists today. As it turns out, Shannon Stevenson has recorded her remarks. We could not hear it while she was speaking, but separately she's recorded it, and we will distribute that to those of you who are here and participating. You'll get a link so you can see her take on the cases that she was going to talk about. You'll receive a link to the presentation and survey to share your thoughts here in the next several days. And I believe the CLE affidavit for attorneys, you'll get a link for that as well. So thank you so much for joining us. Enjoy talking for a little bit, and we'll see you next year.